protection. Thank you. Article 35 on compensation, Article 57 on asset return. Almost all countries say they provide access to remedies, but there's few specifics. The ideas of participation and reparation have not gained broad currency among states parties, as demonstrated, among other things, by the lack of a resolution or even a lot of specific language on victims in this COSP. That's unfortunate. Victims, individual and collective, have a role to play. Focusing on victims, we change the narrative. People understand why it matters what we're doing here, why the school isn't there because the money was stolen. If you focus on victims, you get that shift in narrative. Participation of victims also helps prosecutors do their job better. In the face of hard cases with lots of pressures against them, and it allows for redress, not just compensation, but redress in cases where individuals, groups, or social harm can be identified. And that helps repair the damage done. There are increasing number of cases where courts have recognized the rights of victims to participate in corruption proceedings. Many of these have been collected in a database that I know we talked about earlier today, but I wanted to weigh that again. The Victims of Crime Working Group of the UNCAC Coalition has put together a database that now has information from 22 countries. Please add to it, please look at it, please give us suggestions for what to do with it. It's on the UNCAC Coalition website. This evening's panel will focus on the harms to victims, different efforts to address those harms, and to advance the participation of the people who are directly and indirectly affected by corruption. We have a distinguished panel. I'm not going to give their full bios because it would take a really long time. We have joining us remotely, Julissa Mantilla Falcón of Peru, who's a member of the Inter-American Commission on Human Rights and a longtime human rights advocate, especially working on the rights of women. Catherine Valencia, senior legal advisor from DPLF, an organization working on anti-corruption, human rights, and rule of law in the Americas. Víctor Antonio Fernández Guzmán is a Honduran human rights lawyer and social justice advocate. He was president of the Association of Prosecutors of Honduras from 2006 to 2008, and is a founding member and current director of the Bufete Estudios para la Dignidad. Naomi Augustin there is a social worker and aftercare program manager at Rapha International in Haiti, specializing in trauma-informed services for survivors of trafficking, sexual exploitation, and violence. And next to her is Gerson Nozea, the country director of Rapha International in Haiti. The speakers have been asked to limit their initial remarks so that we have time for questions and discussion. I will send little papers around to the speakers, so if you get a little piece of paper, you know. Also, we have translation both in the room and also on Zoom. So with that, I'd like to turn it over to our first speaker, who will be Julissa Mantilla, I hope.
Hello, good afternoon. Thank you very much for this invitation. It's very much, for me, it's an honor to be in touch with you. I'm really sorry that I couldn't join you there. I love to do that, but as you may know, we are in the middle of internal session in the Inter-American Commission. So I really appreciate it that you are listening to me, even though it's not there. And the other thing that I'm sorry, but I will not be able to be with you until the end, because as you may know, Latin America has a lot of problems during these days, and we as commissioners are, dealing with many issues at the same time. So I think that this is very important in this event and in this panel to related to victims and the role of victims in the anti-corruption actions. And also, as a commissioner, I like to highlight the importance of have this human rights approach to the efforts to combat and to eradicate corruption. Usually when you talk about human rights, we are thinking about torture, disappearance, rule of law, etc. That are human rights violations, but usually people don't understand and don't see the important relationship between human rights violation, human rights activists, victims, and corruption. In the case of the Inter-American Commission of Human Rights, besides all the efforts and the reports and our role, that is important to highlight just in a minute, because I'm not sure if everybody knows what's the role of the Commission. First of all, the Commission is different than the Inter-American Court, and we deal not only with cases, but also with the monitoring mandate that implies to monitor the situation of human rights in the region, including corruption. That's why, and this is the first thing that I like to highlight, is that in 2017, the Commission passed one resolution concerning human rights and the fight of corruption related to specifically the case of Guatemala. What happened there at that time is that the government of Guatemala declared the head of the Commission Against Impunity in Guatemala as a persona non grata and ordered his expulsion from the country. In that resolution, the Inter-American Commission not only referred to the work of this Commission Against Impunity in Guatemala, but also established the importance to make a link between combating impunity and combating corruption, you know? And this was one approach that currently it is important to have in mind. I know that you all are aware of the situation in Guatemala right now and all the problems that democracy is having in Guatemala. So at that time, the Commission in 2017 started, you know, having this discussion about human rights and the fight against impunity as a condition, important condition for combat corruption. In 2018, the Commission passed another resolution, more specific resolution on corruption and human rights, stating that corrupt management on public resources jeopardizes the capacity of government to meet their obligation with respect to social rights, including healthcare, education, water, transport, etc. And the Commission states that this, you know, fighting corruption, make possible for the states to comply with their obligation concerning economical, social, and cultural rights. And in this resolution, the Commission also started talking about the different impact of corruption in different groups. It's not the same for Afro-descendants, human rights defenders, women, LGBT, etc. So it was 2017, 2018, and 2019 when we passed a report that I recommend to review, that is the corruption and human rights in the Americas, and with our Inter-American standards. We analyzed this phenomenon of corruption from a human rights perspective. And at that time, the Commission established a series of fundamental principles to develop anti-corruption public policies. Among all of these principles, I mean, it includes the strengthening of the rule of law, the participation and social inclusion, the access to justice, and specifically the centrality of the victim of corruption and the need for adequate reparations policies. You know, and this is the other argument that I like to highlight, because it's not only, you know, to identify victims of corruption, but also to identify public policy of reparations. And not only that, is that to include them in any effort, a state effort or particular effort to combat corruption. So I know that I have only 2 minutes, but as a rapporteur of human rights in the Commission, I think that it's important to highlight the different impact of corruption related to women. You know, one of the key risks of corruption that directly affected of women deals with sexual corruption. And the Commission has collected a lot of testimonies from women and girls that suffer this kind of corruption that is particular for them. One example is the situation on female migrants. You know, when they not only have to pay money to cross the frontiers, but also to be victims of rapes, not only by the illegal traffickers, but also by public officers, including police forces, including judges, prosecutors, etc. So if we start thinking about corruption with a different perspective, it's not only money, it's also what happened with sexual violence or sexual corruption, as the World Bank has in their studies so far. The other thing is related with women, human trafficking in general, because you know, when you're talking about human trafficking, usually you think about the whole gang, but aim on this gang, there is women victims of trafficking that usually are punished as if they were the trafficker as well, and it's not like that. So to receive the condition of victim against sexual corruption, sexual violence. And the other perspective, just to finish this part, is that how important is to highlight the situation of corruption related to public services, especially with women. Why? Because as we all know, there is a structural discrimination that put women in the low spheres of the development. So women are the poorest segment of the population, so they have to access more than men to public health services, to public education, they are less paid, unpaid. So in this whole situation, women are more affected. So one recommendation from the Commission is to have this different approach to corruption, to have a specific data about what's going on with different groups, and especially in the case of women. And finally, just to finish, one important element to fight corruption is the judicial power, you know, and judiciary corruption is something so incredible developed that it also requires a gender approach. I will recommend this professor from Peru, Rocío Villanueva. She has a special article about this gender stereotype and corruption, but some things just for you to think about it. When we think about corruption, usually we think about this whole, you know, programs or whole situation. Like for instance, the Odebrecht case, just these big cases of corruption, you know, but there is something like the normal or usual corruption in the judicial power dealing with rape and sexual violence. You know, usually rape and sexual violence against poor girls or poor women are crimes that nobody cares about. So it's easier to get this little corruption that is more common, you know, and it's like kind of invisible. And that's why, in this sense of this international standard, inter-American standards against corruption, we should include a gender perspective, and we should include this specific view and the need of specific data of information of what's going on with women and girls. Thank you very much.
Thank you very much for that perspective and for being with us this evening, despite everything else that's going on in the hemisphere, which I understand is quite a bit. I'd like to turn now to Víctor Fernández, who's going to speak about his work in Honduras.
Sí, sí. Buenas tardes, muchas gracias Naomi, muchas gracias a quienes nos siguen en este panel. Voy a intentar en estos 5 minutos desarrollar, primero la idea central es cómo podemos bajar el enfoque de la corrupción desde los medios de comunicación, desde el escándalo y de otras perspectivas que sí son importantes para resaltar la importancia que tienen las víctimas directas de la corrupción. Muchas veces olvidadas, muchas veces marginalizadas por el mismo sistema. Y sobre esa base quiero intentar desarrollar 3 ideas. La primera es las víctimas, particularmente voy a hablar de las víctimas de comunidades o de pueblos indígenas de la corrupción, como sujetos históricos y como sujetos del proceso penal que han venido reconstruyendo o construyendo la otra historia de lucha contra la corrupción. Y para eso me voy a permitir pues reiterar que los pueblos indígenas vienen siendo víctimas del abuso de los grupos hegemónicos, estatales o económicos, y tienen esa lucha histórica por reivindicar su derecho, su existencia, y que han venido trascendiendo, poniendo sobre la mesa la discusión de esa perspectiva de la corrupción y sus impactos en poblaciones, particularmente las poblaciones indígenas. Y de esa perspectiva histórica han saltado a la perspectiva de sujetos de los procesos penales cuando se enjuician a personas, a funcionarios vinculados a actos de corrupción. Y me permito en este caso entonces citar lo que nosotros hemos hecho con los pueblos indígenas, con algunos pueblos indígenas de Honduras, particularmente con el pueblo indígena Lenca, que por ejemplo desde 2014 denunció 49 proyectos hidroeléctricos concesionados a empresas bajo mecanismos y formas de corrupción. Entre ellas aparece la concesión de las aguas del río Hualcarque, que finalmente la empresa a la que se le concesionó no solo obtuvo su concesión bajo formas de corrupción, sino que desencadenó una serie de violencias, entre ellos el asesinato de la lideresa hondureña Berta Cáceres en marzo del 2016. Nosotros, como representación del pueblo lenca, del COPIN en este caso, abrimos una causa por corrupción desde 2014 y esta solo pudo ser presentada por la presión ejercida por el pueblo lenca como consecuencia del asesinato de Berta Cáceres hasta el 2019, que permitió la acusación de una red de corrupción integrada al menos por 16 funcionarios públicos. Lo que queremos rescatar de esto es que ese caso nunca se hubiera presentado, nunca se hubiera sostenido, si no es por el papel beligerante de unas víctimas históricamente marginalizadas como los pueblos indígenas. Y hoy estamos a las puertas de una sentencia que puede marcar un precedente y que puede rescatar los derechos humanos conculcados por esta red de corrupción que integra a grupos económicos y que integra, por supuesto, a funcionarios públicos. Quiero destacar que en este caso, el COPIN, que es la organización que planteó la acusación, fue excluida del proceso, porque el sistema de justicia no entiende que las víctimas directas, como los pueblos indígenas, podrían participar del proceso penal. Sin embargo, obtuvimos una sentencia en una acción de amparo que devolvió al sujeto colectivo pueblo indígena a participar y a instar la justicia penal para los autores a la par del Ministerio Público y a la par de la Procuraduría General de la República. Queremos presentarlo como los pueblos indígenas ubicándose, situándose como sujetos históricos y como sujetos que reivindican derechos y que tienen éxito en el marco del proceso penal. Insisto, sin la acción beligerante del pueblo indígena, en este caso, no tuviéramos ni causa penal ni tuviéramos posibilidad de hablar de este enfoque en la persecución de los delitos de corrupción. Y sobre esta base, quiero plantear la segunda idea. Solo la voy a señalar porque entiendo que estoy al límite del tiempo. Es que de la beligerancia que tienen las víctimas, llámese en este caso de la corrupción, pueblos indígenas, quiero plantear la necesidad, el imperativo que hay de flexibilizar, escuchen bien, flexibilizar el monopolio que tiene el Estado de la acción penal pública en los casos de corrupción. Por una cosa fundamental, por la naturaleza de nuestros estados, por la dinámica en que funciona la corrupción en nuestros países, en nuestros estados. Es incluso, a juicio nuestro, una inmoralidad que el Estado se atribuya el monopolio de la acción cuando el funcionamiento de los Estados está cruzado por una serie de connivencias con prácticas de corrupción que a la postre surten efecto en los procesos penales. Y una tercera cosa, solo menciono la idea, puedo abundar sobre eso en su momento, pero la tercera cosa que quiero plantear es el tema de reparación de las víctimas. Es decir, ya el hecho de que las víctimas puedan participar, puedan asumir su condición de sujetas en el proceso, es decir, de obtener la beligerancia, de reivindicar sus derechos, es una forma de reparación. Y mucho más, obteniendo esa condición de sujeto, construir el modelo de reparación por participación directa, por reconocimiento propio, es de verdad la manera más destacable de rescatar la historia que hay sobre los pueblos indígenas víctimas de tantas cosas y víctimas de la exclusión en los procesos penales, porque nadie más puede construir un modelo de reparación que las propias víctimas. Insisto, sobre este tema también sería insustentable que el Estado, que actores, que terceros se planteen un modelo de reparación sin participación de las víctimas. Esas tres ideas quería plantear y esas las he presentado en el tiempo justo. Gracias. Gracias.
Muchas gracias, Víctor. Mucho que platicar. Ahí vamos a regresar, espero, sobre alguno de esos temas. Sorry. It's been one of those days. There's a lot of important ideas here, and we'll come back to them. But now I want to turn to Gerson to talk a little bit about the experiences of Rapha.
Thank you, Naomi, for giving me the floor. In the interest of time, Naomi on my left, my colleague Naomi on my left, will be sharing our 5 minutes. So I'll just proceed with the introduction of her topic, and then she'll take over. The goal of this intervention today is to highlight the impact of corruption on gender-based violence. Although the two may not seem to be related, but in reality, depleting and diverting community resources through grand corruption practices lead to rapid deterioration and erosion of positive social norms. As communities become more, as resources within the communities become scarcer, basic services such as access to education, sanitation, access to healthcare, those become very difficult for people to access. And this situation leads to eventually to heightened level of violence within communities that already have are grappling with other issues. So in this context, what we've seen is that this heightened vulnerability in turns create a condition in which the most vulnerable groups within the communities face a lot of difficulties in specifically women and girls. And corruption is also a major obstacle to fueling conflicts that can be widespread within countries. We've seen that in our region. It also widens the gender gap, which we've been fighting for several decades now to bridge the gap, but we've seen increasing in many of our countries. We've seen that this gap is broadening instead of being shrinking. So while the gender specifically is not specifically mentioned or included in the UNCAC, but it is one of the imperative point into achieving the SDGs and closing the gender gap and eliminating gender-based violence is very important to reach our goal, the SDGs goal. Gender is present in most of the SDGs, and because it lies in the intersection of economic, social, and environmental issues. It has its own goal, which is the SDG 5, to achieve gender equality and empower all women and girls, and is explicitly mentioned in 10 other SDG goals. So the full realization of the SDGs, SDGs depends heavily on women's political participation, social engagement, and economic contribution. If violence enabled by corruption continues to hold women's back, so the whole the global progress that we're trying to achieve, not only within the spectrum of women's right, but in general, will also see some setback. So it is important that when we are addressing corruption, given that the effect that it has on women and girls, that we put women and girls in the center of addressing corruption from a human-centered approach. With that, I will pass the floor to my colleague Naomi, who will speak more extensively about experiences that we have with working with women affected by violence due to corruption in communities, and some of the work that our approach to build resilience, not only to violence, but also to the corruption that is at the root of the violence that we've seen in the communities. Thank you.
Je remercie les organisateurs de l'opportunité de participer sur ce panel et de parler des effets de la corruption sur les victimes de violences basées sur le genre. Comme vous le savez tous, la corruption est néfaste et nuit gravement au bon fonctionnement d'une société. Les derniers développements en matière de corruption ne cessent de mettre en difficulté les groupes les plus vulnérables et de limiter le soutien institutionnel auquel ils pourraient prétendre. Les impacts de la corruption sont multiples et affectent nos efforts pour soutenir les groupes vulnérables, victimes de la traite des êtres humains, et les violences basées sur le genre affectent de manière disproportionnée les femmes et les filles. Dans de nombreuses communautés marginalisées, la prolifération des groupes armés entraîne une recrudescence de la violence communautaire, qui n'est pas sans lien avec le trafic d'armes par le biais de la contrebande et de la corruption. Depuis, des centaines de cas de violences sexuelles à l'encontre des femmes et des jeunes filles ont été recensés dans les quartiers contrôlés par les groupes armés. Dans les communautés les plus affectées par le crime organisé soutenu par la corruption, la réponse judiciaire tant attendue est quasiment inexistante. Les victimes se heurtent à des obstacles dans le système judiciaire qui réduisent la possibilité d'un traitement juste et équitable de leur cas. Les femmes et les jeunes filles victimes de traite et de violences sexuelles de la part des gangs et d'autres membres de leur communauté ont peur de demander justice parce qu'elles pensent que le système judiciaire est corrompu et que le fait de demander justice peut conduire à de nouvelles violences. Une étude publiée par le GI Talk en mars dernier sur les communautés les plus affectées par les groupes criminels organisés montre que 84% des femmes et des filles victimes d'abus sexuels dans ces communautés ont une opinion négative du système judiciaire. Voici un exemple de cas avec lequel on a travaillé. Une jeune fille de 16 ans a été abusée sexuellement par un ami de son frère et a porté plainte. L'agresseur, qui a été arrêté, a menacé la victime et son frère. Et ils ont demandé une protection vers les instances concernées et cette protection ne leur a pas été octroyée. Moins d'une semaine plus tard, l'agresseur a été libéré et a assassiné le frère de la victime. La famille a exprimé un profond regret d'avoir dû recourir à la justice. Et la victime s'est sentie encore plus coupable du fait qu'elle a perdu son frère. En termes d'intervention, nous avons offert une prise en charge holistique pour cette victime. L'impunité est l'un des plus grands alliés de la corruption. Lorsque la justice n'est pas rendue, les communautés sombrent dans le désespoir et la violence devient inhabituelle et acceptable. Lorsque la violence devient acceptable, les communautés perdent la volonté de lutter pour la justice. Nous avons travaillé avec un deuxième cas, une femme de 44 ans qui a été attaquée, sa maison a été brûlée et elle a perdu ses 2 parents et son fils. On a dû travailler avec elle, surtout sur son traumatisme, et elle a bénéficié d'un soutien psychosocial et elle a commencé à travailler sur son autonomisation. Suite à ces considérations, nous proposons quelques recommandations de bonnes pratiques pour lutter contre la corruption. Premièrement, nous proposons de renforcer la résilience de la communauté grâce à des services psychosociaux et la création de systèmes solides de protection des victimes afin de permettre aux survivants de demander justice sans compromettre leur sécurité. Ensuite, de collaborer avec les acteurs gouvernementaux et de la société civile concernés pour remédier aux faiblesses des services de prévention et d'aide aux victimes. Merci beaucoup.
Thank you. Let me turn to Catherine to finish our panel out. Thank you.
Thank you, Naomi. And I just want to acknowledge the interpreters and thank them as well. The Due Process of Law Foundation, which is the NGO where I work, is a human rights organization focused on Latin America and based in Washington, D.C. And we work to raise awareness through legal mechanisms and advocacy about how corruption, especially grand corruption, impacts human rights and the citizens of the Americas, and also how human rights tools and the human rights perspective can aid in the fight against corruption. We have been honored to support a case of victim participation that we believe is emblematic of this dual approach that also emphasizes the importance of adopting an intersectional and gender perspective in tackling corruption. In this situation, the victims have thus far been, been unable to effectively access remedy at the local or national level, so they have utilized creative and strategic litigation to demand justice through international human rights mechanisms, namely the Inter-American System. And the facts of this case center around a group of 12 women in South America who are or were living with breast cancer. A civil society organization called Mama provides psychosocial and other support to breast cancer patients and advocates for their rights. The country in which this organization is located has been experiencing a complex humanitarian emergency for many years. And a factor in this emergency is the context of grand structural corruption, which has decimated the public health system on which so many people rely. And the breast cancer patients in particular were no longer able to access the medications and treatments such as chemotherapy and radiation that they urgently needed. As a result, in 2019, the group of breast cancer patients filed a precautionary measures request to the Inter-American Commission on Human Rights, who we heard from earlier. Precautionary measures are a type of protective order that the Commission will issue in situations that are serious and urgent and that seek to prevent irreparable harm. The request filed by the victims details the treatments and medicines that they needed and how they were denied these treatments by the state health system. And the request noted that one of the victims had filed a report about the lack of availability of medicines to the General Directorate of the health system, but as an immediate consequence, she was removed from the health system and no longer had access to health insurance. So that was a really clear case of reprisals against someone who was reporting a government failure. In 2020, the Inter-American Commission issued the precautionary measures that have been requested, determining that the 12 women were indeed in a serious and urgent situation, needing protection of their human rights to life, personal integrity, and health. And the IACHR requested that the state implement the necessary measures to protect those human rights and facilitate the victims' access to medical treatments and medicines with the incorporation of a gender perspective. So meanwhile, while this legal action was in progress, one of DPLF's partner organizations, namely the National Chapter of Transparency International, we're very pleased that their director is here today in the audience. This chapter of transparency documented through extensive research that the failure of the state to provide essential health services was in large part due to corruption. So these women who had breast cancer could not access treatments in large part due to corruption. So the transparency chapter found evidence of overpayments and double payments in the contracts for medical equipment and treatments made to companies through a trust fund agreement that was established between the country where the victims are based and another South American country. And transparency also found complaints of irregularities and malfeasance in the construction of cancer treatment hospitals since 2012. And those are cases that still remain in impunity today. So using this additional contextual information and evidence about grand corruption, DPLF worked with Mama, the Transparency International chapter, and several other civil society partners to present an updated request to the Inter-American System. And this was necessary because over the course of more than 3 years, the state did not comply with the precautionary measures granted by the Inter-American Commission on Human Rights, and so the victims continued to be denied treatments and medicine. And sadly, 2 of the 12 women who were petitioners in the original request died from breast cancer. So we believe these are pretty clear violations of the right to health, the right to personal integrity, and the right to life that are occurring in a context of grand corruption. Mama has emphasized that the negative consequences of corruption have a greater impact when the human rights holders are women, because women are often in situations of economic vulnerability and they depend on state services, including public health services. So when they are living in a place where there is significant structural corruption that inhibits access to these services, it amplifies inequalities and they become victims of corruption. So in September, the coalition of NGOs presented an additional amplified request to the Inter-American Commission, noting the tragic death of 2 of the victims and adding new victims as petitioners and highlighting this context and evidence about grand corruption that has contributed to the violation of their human rights. The petitioners specifically asked that the Commission request provisional measures from the Inter-American Court, which are additional protective measures that the Inter-American System can issue in cases of extreme gravity and urgency. And the petitioners requested that the commission initiate an ex officio complaint, so essentially presenting a demand on its own initiative against the state for violations of the human rights to life, personal integrity, and health, given the urgency of the situation of the victims and its non-compliance by the state thus far. So the petition has been sent by the commission to the state in question. But again, this amplified petition was just presented a few months ago, so needless to say, this international litigation is still in progress. But our takeaways from this are that in a situation where the state is unwilling or unable to provide redress in cases of grand corruption, victims and their representatives can consider innovative strategies, such as presenting petitions before international human rights bodies that might not traditionally take corruption into account. In addition to the possibilities of long-term remedy and structural changes through eventual reparations orders, we hope, this type of strategy gives victims a voice and an opportunity to engage in advocacy. And the various organizations involved in this case have been engaging in a communications campaign around the case since presenting the updated request. So we hope to raise awareness about the situation of victims in this case, in addition to hopefully eventually receiving legal remedy and the vindication of the victims' rights. Thank you. I'll leave it there.
Great, thank you to all our panelists. I have lots of questions, but given the sort of time, I think what I'd like to do is open it up and see if you have questions. And if you don't, I'll go ahead, but I'd love to get some questions from the floor for any of our panelists first. Yeah.
Voy a hablar en español porque la pregunta es para Víctor. Justo nosotros en México tenemos una situación muy similar a la que planteas, ¿no? Las únicas dos instituciones que pueden dar seguimiento a las denuncias de corrupción son la Auditoría Superior de la Federación, la Secretaría de la Función Pública y en caso de que, y en su caso, la institución afectada por el acto de corrupción. Bueno, de hecho, aquí está una colega, Adriana, que ha hecho muchísimo trabajo en tema de denuncia, o sea, de conseguir la calidad de víctima en casos de corrupción. Justamente porque lo que nosotros vemos es que al final, cuando solo las instituciones le pueden dar seguimiento a las denuncias, pues no hacen nada, ¿no? Nosotros justo hicimos un estudio en el que nos dimos cuenta de que en los últimos 20 años había una sentencia de casos de corrupción o ninguna. Entonces, bueno, lo que quería saber es si ustedes, en dado caso en el que, o sea, porque el caso que tú planteas parece ser que representan a la víctima, ¿no? O sea, la víctima de corrupción. Es decir, hay una gran violación de derechos humanos que involucra un caso de corrupción y hay momentos en los que representan a la víctima. Pero quiero saber si en algún momento ustedes han sido partícipes de un caso de corrupción que no tenga como tal una víctima directa. Es decir, un caso de gran corrupción en el que se desvíen, no sé, millones de recursos para medicinas o algo por el estilo, y si han logrado litigar esos casos y darle seguimiento o tener alguna respuesta positiva. No sé si me estoy dando a entender. No.
Sí lo entiendo. A ver, nuestra experiencia al límite que ha llegado para decir casos en los que no se representa víctima directa, nosotros y muchas instancias en Honduras limitan su rol a presentar la denuncia y no a continuar con el litigio. Aunque entiendo que los colegas de Abogados Sin Fronteras que están en Canadá, que están en Honduras, están intentando intervenir a nivel de representación directa de esas víctimas. Es decir, pero no como terceros que actúan legitimados por sí mismos, por su mandato, sino siempre buscando que sean las víctimas que te legitimen. A partir de lo que establece la legislación procesal en Honduras, que se establece quién tiene condición de víctima, y esa condición de víctima es la que te da la posibilidad de participar en los distintos procesos judiciales. Pero lo que tengo entendido, y a partir de nuestra experiencia, es que se limitan. Nosotros hemos presentado denuncias de corrupción, estas eran denuncias de corrupción, y solo en este caso intentamos entrar a fondo en el litigio porque teníamos la legitimación de las víctimas. Pero solo quiero cerrar en esto. En este caso, la sentencia del caso de amparo, del caso fraude sobre el Hualcarque, hace unas aproximaciones de la jurisprudencia en este tipo de temas, sobre todo en la perspectiva de si la corrupción implica violación de derechos y como tal las víctimas o las organizaciones o colectivos pueden ser titulares de la defensa de esos derechos. Y la conclusión es que como norma no pueden ser titulares de esos derechos. Y hace la cita de la jurisprudencia del sistema interamericano. Y hace la salvedad que en el caso de pueblos indígenas, de comunidades indígenas, sí pueden tener esa condición por aplicación del convenio 169 y la Declaración de Naciones Unidas sobre Pueblos Indígenas. Okay.
Mitch.
Hola, buenas tardes a todos y muchísimas gracias por la presentación de cada uno. Mi pregunta siempre es la misma y Naomi la conoce. Y en este contexto pues se le suma que vemos que para UNCAC es muy difícil incorporar los temas de víctimas. Pero además nosotros queremos ir más allá. A nosotros no nos basta con que se definan víctimas individuales, porque en los casos de corrupción y de gran corrupción, en donde es más importante los procesos, la judicialización, el avance en la lucha, es muy difícil hablar de víctimas individuales, pero el tema de víctimas colectivas está aún más lejos de la discusión de UNCAC. El ejemplo de Venezuela, entiendo que pues, en el panel parece que no se puede hablar de países, nosotros tenemos miles de víctimas, mujeres de cáncer de mama, porque se robaron 6 hospitales que nunca construyeron, 6 hospitales gigantescos. Además, miles de millones de medicinas, equipos, etc. En Venezuela esos casos ni siquiera se pueden denunciar. Nosotros los denunciamos, pero ni la fiscalía ni ningún órgano nos acepta las denuncias. Tenemos que salir, pero para salir, entonces nos piden confirmación de las víctimas. Y entonces nosotros, desde Transparencia Venezuela, somos los abogados, tenemos los poderes de las víctimas. Pero conseguir una víctima que tiene cáncer, que tiene años muriéndose porque además no tiene medicamentos, porque el hospital más cerca le puede quedar a 10 horas en carro, no tiene dinero para pagar ese autobús. En esas condiciones, imagínense cómo estarían esas mujeres de desesperadas que conseguimos el poder de 6 mujeres. Creo que esto es una queja colectiva, perdón, pero creo que el avance que tenemos que hacer es demasiado grande. Este no puede ser un avance chiquitito de ir ganando una palabrita hoy y otra mañana. Estamos hablando de que la gente se muere. Y en Venezuela la gente, bueno, y en todos nuestros países hay problemas, ¿no? Pero bueno, me toca hablar solo del mío. Muchas gracias. Y la pregunta entonces para quizás los expertos y Naomi, ¿qué hacemos para avanzar en el concepto de víctima colectiva para que se pueda utilizar jurídicamente?
Voy a contestar rápidamente ya que me preguntas, porque quiero ver si mis colegas también quieren contestar esto. Mira, yo creo que hay casos más fáciles y casos más difíciles, y que lo que es el litigio estratégico es empezar desde un punto y ver cómo se construye sobre ese punto, ¿no? Y yo creo que hay, o sea, el caso que planteó Víctor es un ejemplo de un lugar de donde se puede partir. Así como hay violaciones de los derechos de los pueblos indígenas en Honduras, los hay en muchos otros lugares, ¿no? Y casos relacionados con recursos naturales, con tierras, con agua, ¿no? Donde hay una víctima colectiva muy, no diría muy bien, pero mejor definida, ¿no? Otros ejemplos que a mí se me ocurren tienen que ver con el sector salud, donde tienes un poco lo mismo, ¿no? Hay otros sectores donde hay un problema de un proyecto en un territorio, ¿no? Que afecta a la gente del territorio, que es una víctima colectiva, pero tampoco es todo el país, ¿no? Entonces, de ver esos espacios entre medios como un lugar de donde partir Y el otro camino, y yo siempre he pensado que son dos caminos que se llevan simultáneos, es pensar en la representación de los intereses difusos, de los intereses del daño social, ¿no? Y ahí sí, el papel de las organizaciones que trabajan sobre esos intereses difusos, ¿no? En muchos países de América Latina, por lo menos, hay legislación permitiendo la representación de intereses difusos. Lo que pasa es que no se han usado para corrupción. Entonces, ese es un poco el otro camino que miro yo. Pero le voy a dar la palabra a mis colegas a ver si tienen algo que decir.
Solo un minuto. Es que yo creo que tiene que ver con un asunto normativo, pero también tiene que ver con la voluntad que se tenga por parte de los funcionarios de esto. Nosotros, por ejemplo, en la legislación hondureña hay un artículo, y por eso es importante la vinculación de corrupción y violación de derechos humanos. Es fundamental. El artículo 96, en uno de sus apartados, regula la figura del acusador privado o querellante particular. Y dice en un párrafo que el mismo derecho tendrá a ser querellante particular cualquier persona, natural o jurídica, contra los funcionarios o empleados públicos que en el ejercicio de sus funciones o con ocasión de las mismas hayan violado derechos humanos. Entonces, yo creo que esta línea de entender la corrupción como un impacto directo que constituye violaciones a derechos humanos es una ventana muy importante para poder configurar esta otra posibilidad de querellantes particulares sobre lo que seguramente hay que discutir también, por lo que la ventana que abre la posibilidad de que efectivamente se pierda el monopolio por parte del Estado, del Ministerio Público, y cuáles serían los límites a ese ejercicio. Eso nada más.
I'll just try to comment really briefly because I know we're over time. Thank you, Murchi, for kind of aterrizarnos, for grounding us and speaking to the real lived experience of the victims in this case. It's very powerful. Regarding the question of collective victims and, how can we, you're absolutely right. It's been, I think, challenging or frustrating for some of us here to see how just talking about victims seems controversial. And those of us who normally operate in human rights spaces are like, why is this a big deal? And here we are at the cusp, and we're seeing so much resistance from states, even those that traditionally we think of as human rights allies. So that's, I think, the challenge before us is very great, and it's going to be a long road. But as far as pushing the ball forward, not just for individual victims, but for collective victims, like Murchi said, I think we need to think about activating strategic, and many organizations here and actors here are already doing this, kind of activating multiple international fora and thinking creatively about mechanisms that maybe previously haven't taken a corruption human rights perspective, which are really most international mechanisms, right? So in addition to the inter-American system that I mentioned, there's multiple avenues at the United Nations, of course, in Geneva, the Office of the High Commissioner, the different special rapporteurs that can receive inputs based on the reporting that they're doing annually, the treaty bodies. So those are all, I could go, the list goes on, but I think if we can, I think that organizations continuing to push the ball forward, presenting cases of grand corruption to human rights bodies, talking about human rights at the cost, and in other corruption-oriented fora will hopefully, collectively strengthen the standards of protection for victims everywhere, including collective victims. Thank you.
Yes, I will briefly bring in two elements of responses to this question. If I were to ask for a show of hands within even this room here, how many of us here are from a community-based organization? Probably you will find maybe 2-5% of us here are community-based. So yeah, there is a gap between the people who are affected by those rights violations are in the communities, but they're not represented here. They're represented in most of the UN fora. So while we're fighting for ourselves as organizations, as CSOs, to be included in the UN process in all these processes, but there is also a gap between the victims within the communities and the institutions within the community that are close to the communities and even us. And so basically, if they don't know how could they do? So it is important that as CSOs who are engaged in the UN processes that we connect with community-based organizations, also promote the participation of community-based organizations into the UN processes. So what we know to be true, what we know to be legal rights can be relayed back into the community so the people know their rights. All the good things you said, with the special rapporteur and all of that, if the people don't know that exists, if they're not connected with it, they're not going to use those resources. That's for one. The second thing we've realized by working with victims, like organization is in the communities working with victims. So what happens is that victims have built the wrong type of coping mechanisms. They've accepted violence because they've tried and tried and tried for so many years and they've never seen responses, positive responses. So they fell into a state of hopelessness, which my colleague Naomi touched on. And this is why it is important that we bring the holistic approach, the psychosocial aspect into our approaches to working with victims so we can rehabilitate them, giving them the tools that they need so they can tap into the resources that they need to make things work. If they are operating out of fear, they will never act. Like the examples that my colleague Naomi gave, people are afraid of standing up for themselves. And if community-based organizations don't know the rights that they have, they can't tap into that and enable people to actually seek justice. So justice can exist, all of these things can exist, but if the people don't know it, they cannot access it. It is very important that we do we bridge those gaps as we are actually trying to break gaps into the multilateral spaces.
All right, I think we're out of time. We need to leave it here. I think the message is one of community empowerment. It's one of communities being the subject of these kinds of cases. And it's one of being creative. And I think it's up to all of us to keep being creative, to try to bring victims into the center of these processes, which is where they need to be. And with that, please help me thank the panel for amazing presentations. And thank you.